Meanwhile, we're also in a hearing today in Mississippi for 15-year-old Gregg. She's accused of killing her mother and trying to kill her stepfather. He survived. Detectives say that Gregg called a friend after the shooting and invited them over to see her mom's dead body. Gregg is being charged as an adult. This hearing will determine if Gregg is competent to stand trial. Right now, let's head into Mississippi where this is unfolding. The judge is on the bench. Let's get you into court.
On the record, State of Mississippi versus Carly Madison Gregg, calls number 2024-34169. Who do I have here on behalf of the state?
Captain White Newman, Your Honor.
And on behalf of the defense.
Bridget Hunt, Your Honor.
All right. We have the only matters noticed for hearing today are document number 22, a motion for mental evaluation and McNaughton analysis. Document number 23, a motion for issuance of subpoena ducis tecum to youth court. Document number 24, a motion for issuance of subpoena ducis tecum to Blue Cross Blue Shield of Mississippi. And document number 28, a motion for issuance of subpoena ducis tecum to the Rankin County School District. Additionally, while we're here today, the court's going to conduct the Section 223A, subsection 11B, Juvenile Justice Act hearing that's required every 30 days. All right. This was the state's motion. We'll begin with the issuance for subpoenas ducis tecum. All right, let's begin with the document number 23, the motion for issuance of subpoena ducis tecum to the youth court. Is there any objection to that by the defense?
Your Honor, there is no objection to any of the subpoenas by the defense.
All the subpoena ducis tecum, correct?
All the subpoenas ducis tecum were found to being issued.
Do you have copies I can execute today?
I have orders on the school district and Blue Cross Blue Shield. The state would withdraw its motion with regards to the youth court.
All right. Give me the order. Show the second.
Yes, Your Honor. I don't know if you need to give this marker.
We'll give these to the court administrator and get a copy of them from the clerk's office, okay?
Thank you.
All right. State needs to give me an order withdrawing your motion for subpoena ducis tecum to the youth court, please, so we can keep MEC clean. All right? All right. Next matter on the docket is a motion for mental evaluation and McNaughton analysis. All right. Is there an objection to that by the defense?
No, Your Honor, there's not an objection. We just wanted to make sure that that would occur, the state's mental health evaluation would occur after Dr. Webb has finished his mental health evaluation, which should be finished in July.
I can't assure the defense of that. I don't know. So we're on a pretty tight time frame. Tight time frame here. This case is set for trial, I believe, in September. Is that correct?
Yes, Your Honor.
When is Dr. Webb's report going to be finished?
He should be finished with his report by, I want to say, not the 12th, but the Friday after the 12th.
Okay. Has the state already spoken? Looks like you spoke to Dr. Amanda Gugliana.
That's correct, Your Honor, and she's ready to proceed, assuming that our motion is granted as soon as possible, since we know that we have a trial date in September.
Okay. All right, so you have no objections other than the fact you want it to happen after Dr. Webb's analysis, correct?
Yes, Your Honor, and according to Rule 17 of Mississippi Rules of Criminal Procedure, that's technically the way that it should happen is the state puts forward their mental health evaluation or the defense puts forward their mental health evaluation, and then the state can proceed with the mental health evaluation 10 days after we have declared whether or not, our expert has declared whether or not Carly is competent or incompetent for trial. And as of right now, that can't happen. Yes.
Your Honor, I'm not aware of that being in Rule 17. That's about discovery. Rule 12 is what talks about mental evaluations, and the state is not aware of anything in the rule which requires it to wait until after the defendant has completed its evaluation.
All right, well, let's do this. The only issue that we're in disagreement on is the timing of it. It's the state's motion. I'll let the state argue, then I'll let the defense argue, I'll let the state reply, I'll rule, and we'll be finished. All right? So, can you step to the podium, step to the podium. Ms. Newman, I'll hear what you got to say.
Aaron, the state filed a motion for mental evaluation and McNaughton analysis on June the 17th of this year. Pursuant to the case law cited in that motion, as well as Rule 12, which governs mental evaluations in criminal matters, either party or the court on their own can request that an evaluation be done if there's reasonable grounds to believe that such evaluation should take place. Pursuant to the defendant stating multiple times that they had hired a private evaluator, Dr. Mark Webb, to conduct an evaluation, the state believes that the insanity defense has not properly been alleged, but believe that upon information and belief based on their arguments regarding Dr. Webb, that that's what the defendant intends to introduce as some sort of insanity defense. The state is not required to sit back and wait for them to produce a report claiming that she's insane before funds can be acquired and evaluation can be started on behalf of the state. In fact, the case law talks about once doubt is raised as to someone's competence or insanity, the state bears the burden to prove that they are in fact competent and they are in fact sane. And so the state should not be required to rely on a report by Dr. Webb, who is a private evaluator paid by the defendant, before we are able to have the defendant evaluated. Specifically, we have gone ahead and contacted Dr. Amanda Gugliano, who is one of the psychologists who is certified to complete such evaluations through the Mississippi Department of Mental Health. As the court's aware, the way that the evaluations are conducted back in November of last year changed, and so there's two options for the state of Mississippi. We can go through the state hospital and have them assign someone, or we can go ahead and select someone and contract with them directly. We've chosen that option in order to streamline the mental evaluation. Our trial date is quickly coming upon us. There's nothing to require Dr. Webb to complete his evaluation by the date that counsel has stated in July. There's no guarantee that that will happen. Again, the state's not required to wait until he does that. They've offered no response to our motion. They filed no response. They provided no case law or cited to any statute or law that requires that we wait until after their evaluation is conducted. In fact, the state also, prior to coming to circuit court, tried to agree to a mental evaluation on behalf of the defendant. There was communications back and forth where the state said we would not wait indefinitely in order to have this done. We did not want to have, so to speak, them to drag their feet and say, well, we'll agree to it, but we'll sign it when we want to. I spoke with counsel, Mr. Kevin Camp. He's not in the courtroom today, but I feel certain that he would agree with me that I told him that we would have agreed to an evaluation. However, there was a deadline put on that so that this case would not sit unindicted and without a mental evaluation. Excuse me. Pursuant to our motion, we do ask that the defendant be evaluated both for competency to stand trial as well as a McNaughton analysis. Again, to streamline things, we prefer that it be done at the same time rather than one and then ordering that the other be done subsequent to that. We've asked that any medical, psychiatric, psychological, educational, addiction, or employment records and privilege be waived so that Dr. Gugliano can achieve her evaluation and she can get any records that are necessary, which is also why we filed our motions for subpoena ducis tecum that the defense did not object to in order to get her school records and Blue Cross Blue Shield medical and pharmaceutical records so that we know each and every provider that she saw. The state is again asking that our motion be granted and that we be allowed to use Dr. Gugliano to have this defendant evaluated as soon as possible rather than having to wait until after Dr. Mark Webb is complete with his analysis. Thank you, Your Honor.
Response by the defense.
Yes, Your Honor. Your Honor, Rule 17.4 of the Mississippi Rules of Criminal Procedure states that
There is a lot to unpack here. So the best person to do that, let's bring in our guest watching along with you at home. In Los Angeles, California, friend of the program, we have Marie Pereira. You're a former prosecutor, defense attorney. You're also a registered nurse. The list goes on. First thing that's going through my mind is how common is it to have a teenager as a defendant accused of killing their parent, their mom?
Extremely uncommon, and it's extremely sad too. And frankly, I don't understand why the defense is arguing with prosecution if they want to go ahead and try to evaluate her for possible insanity under the McNaughton rule. It is what it is. What happened here clearly to me says this person was not mentally well and sound, that she murdered her mom, waited for her stepdad to come home to out him too, while all the time playing with her dog and inviting her friend to come and watch. If that's not insane mental disease, making a person incapable of understanding right from wrong, I don't know what else is. And they should allow any testing that needs to be done pre-trial in order to get to the bottom of why this little girl did what she did.
Yeah, and she was only 14 at the time of that alleged brutal attack against her mom and her stepfather, her mom losing her life. So many questions for you, Marie Pereira, about what they have to prove, but we're going to put a pin in it because right now we have to fit in a short break. We're going to be talking about this case much more and bring you back into that courtroom in Mississippi when we return. You're watching Court TV Live, your front row seat to justice.
Tonight on Court TV.
These are the big cases that everyone is talking about.
A lot of new developments taking place.
Shocking.
I know who killed John Bonet.
To say the least.
You cannot make this stuff up.
It's unreal. The scene of the double murders is behind us right here. Things are happening. The investigation is continuing.
Closing arguments with Vinnie Politan. Tonight at 8/7 Central. Only on Court TV.
And welcome back to Court TV Live. I'm Matt Johnson in Dedham, Massachusetts, just outside of Boston. And today we are in Mississippi and we are following a really important hearing involving a teenage girl accused of murdering her mother. Well, she is in court right now for a competency hearing. Prosecutors say the 15-year-old girl, Gregg, was 14 at the time of the shooting. She killed her mother, Ashley Smylie, according to prosecutors, and then waited around to shoot her stepfather, Heath Smylie. He survived with a gunshot wound to the shoulder. Let's get you back into court right now.
Your Honor, Rule 17.4 of the Mississippi Rules of Criminal Procedure states that if a defendant intends to introduce expert testimony relating to mental illness, defect, or other condition bearing upon the issue of whether the defendant had the mental state required for the offense charged, the defendant shall, within the time provided for filing pretrial motions or at such time as the court may direct, serve upon the prosecuting attorney, the clerk of court, notice of such intentions with the names and addresses of such expert witnesses upon which the defense intends to rely. The prosecuting attorney shall serve a notice on the defendant promptly, but in no event less than 10 days prior to trial, stating the names and addresses of any witnesses whom the state intends to rely upon relating to the issue of the defendant's mental condition at the time alleged. The way it is intended, and even the notes under that, talks about the defendant raises it, puts forth their expert opinion, then the prosecutor can rebut if it is found that the defendant has found that they're going to rely upon that. However, at this point, we don't know if we can rely upon that because our expert has not finished his mental health evaluation. Dr. Webb is very reliable, very good at his job, but it takes time. And in this situation, we had a child who is being charged as an adult, but who nevertheless is being kept in a solitary confinement 23 hours a day in an adult facility where he then goes to see her And also, immediately after she was arrested and detained, she was placed on various medications, one being Abilify, which was an antipsychotic, by a nurse practitioner. So there have been medication issues too that Dr. Webb has had to wait to weigh and see what, if any, effects those were having on her. And that's just why it's taking a little time. But like I said, he is due to be done, and we are able to produce his mental health evaluation the Friday after July 12th. I'm not sure how long the state's expert will need or what testing will be involved, but that's well in advance of the September trial date.
Anything further?
No, Your Honor.
All right.
Your Honor, again, 17.4, sorry. Rule 17.4 comes into play once the defendant has filed a written notice. The defendant has not filed any type of written notice in front of this court. The state, however, has provided written notice that we intend to solicit the testimony of Dr. Amanda Gugliano, who is a certified psychologist who would do the testing on the defendant regarding any insanity and or competency. We believe at a minimum she should be able to get started on her competency evaluation with regards to this defendant. Again, there's been no written notice provided by the defendant to put Rule 17.4 into play. With regards to the medication that the defendant may or may not be on, again, if the defense attorney would look back, they would see that the state actually agreed to have her assessed by Region 8 in the beginning, and it was our intention that she be assessed by the Mississippi State Hospital at that point. However, the orders merely provided that she be assessed by Region 8 for evaluation and treatment. We've been asking since the beginning that she be evaluated, and we believe that it would be in both sides' best interest in order for judicial economy in this trial not to be continued if our evaluator would be able to proceed with her evaluation as soon as possible. Thank you, Your Honor.
All right. Court, having heard arguments from both sides, the court is not concerned with the particular written notice. The court's relying mostly on Ballard versus State of Oktibbeha County. The entire purpose of the notice requirement is to prevent trial by ambush for either side. Neither side should be surprised at trial. While I understand the rule says not more than 10 days, it also says unless otherwise ordered by the court. Y'all are both on notice. Y'all are otherwise ordered by this court. We're not going to wait till 10 days before the trial to release all of our information. All right, while the court would prefer for Dr. Webb's report to be complete, I believe this court's experience with mental evaluations is they're normally done in multi-stage on multiple dates. So for that reason, the court's going to grant the state's motion for mental evaluation and McDonald analysis. The court is not going to limit it until after the release of Dr. Webb's report. However, I do believe, from a practical matter, Ms. Gugliano is somewhat hamstrung until she gets Dr. Webb's report. If Dr. Webb's report comes back and says that, hey, there is no McNaughton issue here, we'll double back and we'll deal with that, okay? But what the court doesn't want to do is delay this case. As defense counsel said, she is, this court revoked her bail, and she is being held without bail. So I intend for this trial to go forward in September. All right, for those reasons, the court will grant the motion for mental evaluation. All right, now, as to the Section 223A, subsection 11B of the Juvenile Justice and Delinquency Prevention Act concerning juveniles charged as adults. All right, state have anything it wishes to add on the juvenile justice hearing?
No, sir, Your Honor.
Anything from the defense?
No, Your Honor. Other than there was an incident where an adult inmate who was being housed in the same pod area as Carly was making threats to harm and physically assault Carly, but Carly was able to tell her grandparents, who were able to tell me, and I was able to get someone from the detention center on the phone to handle it.
Mr. Chandler, is she being housed in the general population?
She's isolated, sir.
She's isolated. All right. I don't tell the sheriff how to run his jail, but I believe our sheriff has enough good sense not to put this young lady out in general population at this point. Court looks at the following factors: age of the juvenile, she's 15 years old; physical and mental maturity of the juvenile. The court heard at previous hearings she's a very intelligent juvenile. Present mental state of the juvenile, including whether or not the juvenile represents a risk of self-harm. There was prior testimony regarding self-harm of this particular juvenile while she was not incarcerated. However, the court's heard no such danger while she is incarcerated. Nature and circumstances of the alleged offense do not weigh in favor of the defendant. Juvenile's history of prior delinquent acts. I believe the state court doesn't have anything in front of it yet. The state's moved for a subpoena ducis tecum that may shed more light on that. Did you say you have information that she's...
Yes, sir, Your Honor. Upon information and belief, the defendant was brought some contraband, possibly a knife, to school and was sent to the Learning Center back in September of 2021.
All right. The relative ability of available adult and juvenile detention facilities. Court would know. I worked all over the state of Mississippi. I think that the Rankin County Detention Center is jokingly referred to as the Hilton of jails throughout the state of Mississippi. Rankin County Sheriff's Department runs a very safe jail. For those reasons, the court will not have any change to the juvenile justice detention that she's currently maintained under. Anything further from the state?
None from the state, Your Honor.
Anything further from the defense?
No, Your Honor.
We'll be in recess. Best of luck to both sides.
And it seems like it's not over for that defendant as the judge is going to be making his decision. Let's bring in our guest to discuss this. Still with us, criminal defense attorney, former prosecutor, joining us from Los Angeles, California. We have Marie Pereira. Marie, my question to you, competency. How is that determined? What do they need to prove or not prove?
They need to prove that because of her mental disease, she was incapable of understanding legally and morally right from wrong. So she didn't really understand shooting someone in the chin, in the face, attempting to kill somebody was not legal and it's not moral because she is suffering from mental disease and could not wrap her head around the fact that something like that is wrong. That negates intent. To have intent, you have to have a mind to create that intent. No mens rea when you're insane. And I think this child had a history of mental disease even before this happened. She was on medication. When you look at her, she doesn't even look like a 15-year-old. She looks even younger than that. She needed to be evaluated, and I agree with the judge that they're granting the state's motion even before defense completes their evaluation because clearly we're looking for justice, and I think part of the justice is to evaluate this child's mental status.
Yeah, but our system also is a system of rehabilitation where possible. When you have a defendant that is 14, now 15, not even at the trial phase yet, the innocence guilt, what is this child looking at? Life behind bars, potentially, if convicted?
No,
or is there a possibility of getting out on the street?
There is a possibility. If they deem her not guilty by reason of insanity, she's committed to a mental institution, at which point she will get treatment and doctors will evaluate her throughout her lifespan in that facility to see, is she safe to leave now? Is she a danger to herself? Is she a danger to the community? It is not a forever sentence. It's until such a time that experts treat her and see what's going on in her mind.